Good morning, everybody. Welcome to this to this InZone workshop, and we have the pleasure of hosting Mr. Shuteriqi, who has very gallantly offered to give us this workshop on a topic that we're all interested in, which is international law and protection of refugees and migrants. Now, uh, Ms. Shuteriqi is a professional in the humanitarian world. She has over 20 years of professional experience in that domain, working for various organizations such as UNICEF and Terre, and she is currently Director of Policy at the ICVA, which is the International Council of Voluntary Agencies. Can I ask, the way this is going to go, Mirela is going to give us a brief presentation. She'll take it from here. Obviously, feel free if you have any questions to wait until the end of the presentation. You can put them in the message board. We will then obviously address them in the Q&A session, which will take place after this presentation. So let's all welcome Mirela and thank her again for her time. And we are very, very curious looking forward to her presentation. Mirela, up to you.
Thank you, Lou, and hello, everyone. It's indeed a pleasure for me to be with you here today. I wish it was in person, but maybe we'll have such an occasion in the future. As Lou mentioned, I will make a short presentation on the international legal framework that serves the protection of refugees and migrants. It's quite a complex topic also because there is a big discrepancy, unfortunately, between what is in paper in terms of international legal framework and the reality on the ground. And you know that better than me. But this is also an opportunity to exchange together about how it all works. And I would be also very much interested to hear from you, not only in terms of questions, but also about your experiences and how you see the implementation of this international legal framework in your daily life. So I have prepared a PowerPoint presentation that is quite long actually, but maybe we can go through it quickly and not necessarily cover all the slides or cover them very briefly. And as Lou mentioned, please feel free to ask questions at the end of the presentation. So in terms of objectives of this session, as I said, I will make a bit of an introduction to international law. I don't know about your backgrounds, but I thought it would be useful to have a bit of discussions about who are the subjects of international law, what are the sources, how it works, before we go concretely into the legal framework for the protection of refugees and migrants. Then we'll see concretely the legal branches that play a role in protecting refugees and migrants, the legal instruments, and we'll discuss together the content and application on the ground. And then we'll have time for listening to your comments and questions. So, when we speak about international public law, we have to understand first who are the subjects, which means which are these entities of internet that have competences under international law. What does it mean having competences? It means that they can enter into treaties, international treaties. They can become signatory to international treaties. They are recognized to have privileges and immunities under international law. They have a capacity to make international claims, and also they have responsibilities for non-implementation of international law. So if we list this criteria, of course, the first entity that is subject of international public law and is the main subject actually is the state. So international law regulates the relations among states and is made by the states themselves. Nowadays, and especially after the Second World War, we have also international organizations which have which have personality under international law. We know that international organizations they can enter into different agreements, international agreements among themselves, but also with the states. With international organizations, I refer to international organizations at the global level, like, for example, International Organization for Migration or UNICEF, but also to regional organizations like African Union or the European Union. Now, under international law, initially the thinking was that individuals are not subjects of international public law. On the contrary, they are objects. But with the development of international criminal law, we know that individuals have increasingly responsibility under international law, especially for crimes against humanity, for genocide, for war crimes, and so on. So there is also, in theory at least, a recognition of individuals as subjects of international law. And here we speak about individuals and also a group of individuals. And lastly, the multinational companies, NGOs, and other organizations it's not really accepted today that they have a responsibility and they are subjects of international public law. However, there is a school of thought that argues for a recognized responsibility of multinational companies for violation of international law, especially for violation of human rights law. So after discussing this, the subjects, the main subjects we have to keep in mind is the states and then the international organizations. The sources of international law, very important as well. Here we look at the International Court of Justice statute, which describes specifically in its Article 38, which are the sources of international public law. And it refers mainly to treaties. These are agreements concluded between states or states and international organizations or international organizations themselves. Customary international law, these are rules of behavior, unwritten rules of behavior, which states comply with because they think that they are binding upon them. This is the way things should be done. Today, most of the customary international law, actually, it's translated into treaties, so there are very few unwritten rules in international law today. And then there are also general principles of law, like principles of necessity, for example, proportionality. Again, even most of these principles of law are today included in different treaties and international agreements. Now, these are the main traditional sources. Then we have supplementary means. These are not really sources of international law, but they help in the interpretation of the international law. And this is the jurisprudence. For example, if we have a treaty and we are not sure about what is meant by an article of this treaty, we look at the jurisprudence or if the International Court of Justice has said anything about the interpretation of this article or the interpretation of a treaty itself, which can help us to understand what does it mean in a specific situation. And then there is also soft law. With soft law, we mean different, for example, General Assembly resolution of the United Nations. We look at the scholars of international law. What have they said about a specific treaty? will know that the different human rights treaty, for example, they have a committee in place which looks at the interpretation of a treaty, and the comments that this committee does are also considered soft law in the sense that they help to understand what does this law mean and how it should be implemented in different contexts. When we speak about international migration law, and I'm using the term international migration law to include the refugee law in there, we speak about this body of law, which on one side describes the rights and duties of migrants and refugees, and on the other hand, describes the competencies, the rights, and the obligations of the states. And together, the two elements form the rules of international migrant law. So this is still a bit abstract, I guess, for you, but now we can go a bit more concretely and look at the different areas or branches of international law which are relevant in terms of protection of refugee and migrants. And first of all, we have human rights law, because human rights law, they apply to everyone, including refugees and migrants. So they apply to all human beings, regardless of a migration status, regardless of a refugee status in general. Of course, there are exceptions, and we'll look at it a bit later on. We also speak about the refugee law, which is the body of law that looks in specific at the rights and obligations of those people who are recognized as refugees, and also the obligations of states versus the refugees. We also speak about international labor law, and why is international labor law relevant? Because, of course, it looks at labor law, the rights of workers, including migrant workers. We speak about statelessness law. We have many stateless persons who are citizens of a country, who normally should be citizens of the country that they live in, but also who comes from other countries. And the fact that they don't have a nationality makes their situation even more complicated than the situation of foreigners. But we'll see that under international law, they have also rights, and states have obligations towards their protections. Then we speak about consular and diplomatic law. This is also very important because it recognizes, for example, the right of states to protect their own citizens while they are abroad. If I'm a Swiss citizen, for example, and I'll go abroad on holidays in Italy, and I'm alleged for committing a crime in Italy, for example, and get arrested, I have a right to contact the consulate of Switzerland in Italy, and the consulate of Switzerland in Italy has the right to come and visit me in prison and be in contact and seek to support me. So that's why this is important in terms of protection of migrants and refugees. Then we have the law of the sea. And the law of the sea is also very relevant because it has, among others, some rules about the rescue operations at the sea. And we know that many refugees and migrants try to reach their destination countries through sea routes, and often they come at danger at sea and need a rescue operation. So what are the obligations of states to save and rescue these migrants and refugees on sea? These are all regulated by the law of the sea. We have international transnational criminal law. This is, for example, the different rules about the protection against trafficking in human being. You know, trafficking in human being is the transportation of someone for the purpose of exploitation. And this transportation can occur within the country of a person or across international borders. So when we have transportation and a movement across border, we have a case of a foreigner, we have a case of migrant, and that's why this is as a relevant as a branch of law. We have international humanitarian law. In international humanitarian law, we have rules about the protection of civilians in cases of war. And here we also have protection of civilians that are foreigners. This can be refugees or migrants, it doesn't matter, they are protected by international humanitarian law. We have international private law, also very important in case a refugee is married in the country of origin, but then he moves as a refugee in another country. International private law recognizes his marriage in the country of destination, or the property rights, and so on. International trade law, and so on. So there are many branches of international law that are actually relevant in terms of protection of refugee and migrants. And we'll not go into details with all of them because it will take ages, but we'll cover some of the most important ones, and namely human rights law and refugee law. Here I have made like a list of different relevant treaties for the branches of law, and they play a role in terms of protection of refugees and migrants. As I said, there is no point in going into details into all of them. I already covered a bit how the different branches contribute to the protection of refugees and migrants. But maybe I will mention the human rights treaties in specific because they are very relevant. So we have a Universal Declaration of Human Rights, and this is dating back to 1948. And after the Universal Declaration of Human Rights, there are 9 core human rights treaties, which are states have ratified under the United Nations auspices. And sometimes we have also optional protocols which have also been ratified by states. For the states that have ratified these international treaties, it means that they are bounded by these international treaties. It means that they have to ensure that the rules of these treaties are translated into national legislation and are implemented in the national level. So the main international human rights treaties are the International Convention on the Elimination of All Forms of Racial Discrimination. So the title gives you a bit the content of and the focus of the convention. This is really about fighting racial discrimination. Then there is the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the Convention on the Elimination of All Forms of Discrimination against Women, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, the International Convention on the Protection of the Rights of All Migrant Workers, the International Convention on the Protection of All Persons from Enforced Disappearance, Convention on the Rights of Persons with Disabilities, and I forgot to mention here the CRC is the Convention on the Rights of a Child. So this convention applies to all persons that find themselves on the territory of the states that have ratified the convention, first also on the refugee and migrants that find themselves on this territory. And then we'll speak also later on about the refugee law and what conventions are relevant under refugee law. I don't know if it is worth it to stop a bit here and take some questions, or if it is better to continue with the rest of the presentation. Lou, what is your view? Should I continue or maybe break for some questions along there?
I would say if there are questions at this point, we should open the floor.
Okay, so then let's open the questions. The floor for questions are already here, and then I continue after with the presentation. Colleagues.
So if you have any questions, for those with a microphone, no problem. Others, you can leave them in the comments. Even throughout the presentation, feel free to ask or to write your questions in the general comment board, and they will be answered. Are there any questions at this point?
Hello, let me has a question, Lou.
Please, Amarat.
Yes, I think you've thank you so much. You've shown us, I mean, the rights that constitute the international law, and then do states choose which law they want to actually abide with and ignore others? The reason being, I think you've seen, for example, some countries, I don't want to mention, but some of them are not. You'll hear them not recognizing refugee laws, because in some countries a refugee can be detained and I mean, you don't actually be recognized, but now some countries, you hear them actually recognizing that. So what I mean, do countries get to choose, I mean, from all these international law, they get to choose what they want to follow and then ignore the rest?
Thank you very much for this question. I will come to this a bit later in the presentation. So if you allow me to continue with the presentation, I think you will have the answer to this question. Let me see. There are also another question right now. And if not, we continue with the presentation, because I think many elements will come out during the presentation anyway, like the question that Almarat had.
I think we have a question from Dominic.
Yes, sure. Please, Dominic.
Yes, thank you so much, Miss, for the wonderful presentation. My question got to go like this. Under the international law that protect the refugee in the marine, recently, I'm in Kenya. I'm in Kakuma refugee camp, which is particularly in Kenya, and maybe I married to a Kenyan. Then the time I married to a Kenyan, we get to build a house together and maybe other properties, and we share other properties. Then maybe through breakup, you never know in the future through breakup, the Kenyans, the Kenyan wife, maybe will want to take all properties because I'm not a Kenyan, maybe I was a refugee, but I married to a Kenyan. Then according to Kenya constitution, allows maybe a Kenyan to take all properties, and because I'm a refugee, I'm a foreigner, I'm not supposed to share that property equal to the human. How the international law that protects refugees that are married to the host country. How am I going to protect it on that scenario? Or maybe is that international law that protect refugees that married to a host to the host? Is that refugee that country? Yeah, that country that hosts the refugees. Is that are they abide under the international law that protect the refugees?
Thank you, Dominic. Thank you, Dominic. Unfortunately, I couldn't hear you all the time. You were coming broken. So would you mind, please, just for me to be sure that I understand properly, to write down the case in the chat box? It will help me to look at properly and make sure that I don't miss any element, and then I will answer to to you based on the information you provide on the chat box. Yes?
Okay, okay, thank you. Yes, I'll do so.
Thank you. That's very kind of you. So I suggest I continue also because
Yes.
of making sure that we'll have enough time. And then I will come back to the question of Almara during the presentation and Dominique based on the information in the chat box. So human rights, we already spoke a bit about the different human rights instruments, and what is important is to make to also keep in mind that human rights treaties, they recognize both civil rights like the right to life and physical integrity, the right to liberty, freedom, the right to freedom of movement, the right to freedom of assembly, the right to respect for private and family life, the right to access to justice or access to courts, but also economic and social cultural rights. With economic, social, and cultural rights, we refer, for example, to the right to health, the right to adequate standard of living, the right to education, all the labor rights, cultural identity rights, and so on. When we speak about responsibilities, and this came also clear from the discussion and the two questions that I received, of course, the main duty bearer is the states. And as I mentioned, states have a responsibility to protect all individuals under their jurisdiction, so under their territory or under the areas where the state has effective control. States have also a responsibility based on international law to protect its nationals abroad. As I mentioned, if I go on holidays and I am arrested under allegations of a crime, my state of origin has the obligation to make sure that they reach me, offer me a lawyer, and so on. When we speak about the obligations of state, they mean the obligation to respect human rights. This means that states should ensure that they, for example, do not violate my rights. For example, the right to life. This means that the police should refrain from intentionally putting life at danger unless this is the only means for self-defense. So states should refrain from violating my right, for example, to freedom of association. If I want to be part of an organization, states should allow this from happening. There is the obligation of a state to protect. This means that states should ensure that my rights are not violated by other actors. For example, that states should ensure that my employer does allow me to participate, for example, in trade unions. Then the states have also the obligation to fulfill human rights. This means that they should take proactive measures to ensure that citizens and individuals that live on their territory realize their rights. For example, the right to education. State should undertake measures to ensure that all persons living on a territory access education. So these are very important in terms of what consists the state's obligations. Of course, under international law, there are also limitations to the rights and the obligations of the states. And it is important that when we speak about these limitations or restrictions, they should be prescribed by law to avoid that they are like that they are subjective, and each authority of a state comes up with its own restrictions to the rights of individuals. And also they should be necessary and proportionate. And you will see that very often there is a judge that looks whether the restriction to the right of an individual is really proportional to the interest of the state to protect the rights of other individuals or to protect its own security. We have also the concept of derogation of rights under international law. And by this, we mean that a state can also stop the recognition of certain rights during a certain period of time, especially during, for example, a situation of emergency, being this like military emergency or a natural emergency. States can stop the application and the recognition of certain rights. For example, the freedom of assembly is not recognized during a situation of natural disaster because this would put further at risk the citizens and the individuals. So for the derogation of rights, they should be not discriminatory applied. So it means that they should apply to everyone living on a territory. They should be limited on time, so during only the period that there is an emergency. And they should be notified in advance. So the state cannot say after the fact has happened that, but we arrested these people because they went out for a demonstration and actually we had derogated the right to freedom of manifestation.
I'm sorry, Mirela.
Yes.
I believe you're sharing your second screen. We do not see your PowerPoint presentation.
How come? Okay, just I should stop then sharing the screen. I don't know how this happened. And we go to sharing then. Just one moment. You don't see this slide?
No. We see the actual university launch meeting Zoom page.
Oh, that's strange. What about now?
Still no.
No?
No. Sorry.
I don't know how to use this.
Otherwise,
maybe stop sharing and restart then.
Yes, that might do it. Yes, now we see it.
Okay, sorry for that.
No problem, thank you.
So thank you for letting me know. Now we come to the question that Almarat had, that we speak about, unfortunately, some differences and discrepancy between the situation on what is recognized on paper in the different international agreements and the situation on the ground. And when we speak about international law and human rights, actually many of these human rights apply to everyone that finds himself or herself on a state territory. Thus, they apply also to migrants, irrespective of a migratory status, if they are regular or irregular migrants, if they are refugees or just migrants. But on the ground, we know that the reality is different and that many migrants continue to be affected disproportionately by human rights violation. And even though the international law gives them a right These international laws are not adequately translated into national legislation, or even when adequately translated into national legislation, they are not implemented. They are not implemented for different reasons. Sometimes they are not implemented because the government just translated the international law into national obligations, national law, but never took seriously the commitment to ensure its implementation on the ground, especially for refugee and migrants. Other occasions, the government wants to implement them, but does not have the capacity or does not know exactly how to do it, does not have resources to do it adequately. Sometimes it's also not because of the government, but because of other actors that do not ensure that migrants are socially included in the society, and there is discrimination by certain individuals within the society, especially against migrants and refugees. On the side of refugees and migrants, sometimes, of course, they also find it difficult to understand how the legal framework in a new country functions. And of course, sometimes when you don't know the language, when you don't know the culture and the traditions in a new country, it's even more difficult for you. And that's why it's very important that there are service providers like NGOs or associations, even refugee and migrants or diaspora associations that support refugee and migrants with information about what are their rights, what are their entitlements in a new country, how does it work, where they can go, and sometimes also to go together with them so that they help out in the implementation of rights. When we speak about human rights, including international human rights, the first and the most important element of implementation is, of course, at the national level. So, as I mentioned, the state and the government needs to translate its international obligation, what it commits under international law, itself under international law, into national legislation. Now, the international legislation should not remain only on paper, but should be also translated into concrete measures. They should be policy, they should be specific structures that are in charge of implementing this law with a dedicated budget, and they should be concretely working to implement the policy and to build the services that are needed for the refugee and migrants. It's also very important that in case it doesn't function, the refugees and migrants have access to justice. They should go and complain about what is not working, what they are entitled to based on law, but not on practice. And this is ensured through having access to courts, to legal protection and help. This answers a bit your question, Almarat. I hope about the difference between what is recognized on paper in terms of international legal protection, and then what is the situation on the ground. And I'm taking this opportunity to look at a bit also to the other questions. There is one question about refugee movements or forcing them to return in their original countries. I will come back to this question when we speak about the refugee law. There is a question about the Universal Declaration of Human Rights. Everyone has a right to food and other basic needs. Displaced person, even just refugees, some that action inhuman and the violation of human rights. Yes, I agree. As I mentioned, the fact, unfortunately, the fact that human rights are recognized on paper, it does not necessarily mean that they are guaranteed for everyone. However, it's very important to have these human rights recognized on paper, because like this, we can fight for their implementation. We can tell to the states, look, you have signed these international obligations, you have ratified these international legal instruments. What are you doing concretely to implement them? How is it possible that these people within your jurisdiction, within your territory, do not have access to food, for example, while you have committed yourself to ensure food for everyone? So this gives us a possibility to seek to improve the situation. Now there is also another question about non-refoulement and non-discrimination. Okay, I will explain so this. And then there is the question of Dominique, the application of international refugee law in international to marriage and property. Okay, together acquire other shared property. And does international refugee provide protection for me as a refugee? Okay. Here, in this case, Dominique, regardless of refugee status that you have, what applies in terms of family rights and property rights is usually the national legislation that focuses on this. And here you are treated actually in the same ground as a national citizen. So you have the same rights and obligation as a Kenyan citizens, what it regards the divorce or the property rights after divorce. You will not have specific protection here because you have a refugee status. I hope I answered your questions. And then, yes, Richard has a question about refugee laws and national laws, and there should be equal. As I said, in principle, yes. On many rights, refugees should be equal to nationals, but not on all the rights. As I mentioned, even international law recognizes that states can limit some rights for some individuals in specific cases. For example, usually as a foreigner, including as a refugee, you are not allowed to vote in national elections. This is a right that states recognize usually only for all their own nationals. Then some states also apply very broadly they right to limit the rights of individuals and migrants, and come up actually with limitations that are in violations of international law. However, it becomes very difficult for a refugee to stay concretely to the states that, look, you are violating your international obligations. How do you do this concretely as a refugee? Here I will go back to the presentation. I hope you are still looking at the screen. But we have, in addition to the national system of protection of rights, that means that you go to the national judge, you also have a system international and the regional system of protection of rights. With a system, with a regional system, you go actually to the regional bodies, like the African Union and the different bodies, or the European Court of Human Rights. But this you are allowed to do only after you have gone to all the national courts. You have also an international system of protection of human rights, and here you have the charter-based bodies and the treaty-based bodies. The charter-based bodies is based on the UN Charter, and here you have the Human Rights Council. This is not something that individuals can use. This is mainly for states. For example, if the states are not satisfied about the human rights record of I don't know, I mentioned one country like this of Albania, for example, they can go to the Human Rights Council and complain. And the Human Rights Council has a complaint procedure against countries that do not apply with a human rights standards. The Human Rights Council has also established special rapporteurs, and they look at the human rights of specific groups. For example, you have a special rapporteur on human rights of migrants, the special rapporteurs on trafficking in persons. They do look at the human rights of these groups in specific countries, or they look at thematics. For example, the human rights of migrants, the special rapporteur on human rights of migrants can make a report about the practices of refoulement or the practices of pushback at the border. And this report looks at the situation in different countries, and it is discussed at the Human Rights Council. Then the only problem with all this is that actually these bodies come up with a recommendation. So they say that in these cases, this needs to be improved and this can be done, and this is a way to improve the situation. It is up to the state itself then to implement or not these recommendations. And we know that unfortunately, sometimes states also do not implement the recommendation, and this means that the situation doesn't change necessarily on the ground. We have also the treaty-based mechanisms. I mentioned to you different treaties on human rights, and all these treaties actually have a committee. So you have the Human Rights Committee, the Committee on Economic, Social, and Cultural Rights, the Committee on the Rights of a Child, etc. So for the 9 core human rights instruments, you have 9 committees. What these committees do, they look at states' parties' reports. So every 5 years, a state has to write a report about how it is implementing this specific treaty in its own territory. What are the challenges? What are the measures that have been taken to address some of the recommendations from the last time? And here the committee looks at that. They also reach out to different NGOs, to different institutions working in that state to get additional information. And based on that information, they come up again with a recommendation how the state can improve the implementation of that treaty in the country. Very often the committees look at the specific implementation of a treaty in case of refugee and migrants, because they know that even when a treaty is well implemented for nationals of a country, it is not necessarily well implemented for foreigners, migrants, and refugees. So then committee comes up with concrete recommendations on how that can improve. And now I would like to start a bit with in specific, let me see a bit the question, if there is something new. Why there are not reactions to the very many violation cases of human rights violations in DRC, Sudan, Palestine, Myanmar? Okay, again, this is a very good question. I would not say that there are not reactions. There have been reactions. Many states have stated that, for example, what is happening in Palestine is not acceptable and things should change and so on. However, as I mentioned, the problem at the international level is that you cannot have a direct enforcement of international law. This means that if there is a violation, for example, of international law, the maximum you can bring that complaint to the International Committee, or you can bring it to the International Court of Justice, or to the International Criminal Court. However, and this is the best case scenario to bring it to these courts, once you bring it to these courts, it takes very long for the courts to consider the case. You know that there have been some cases in the International Court of Justice about the situation in Gaza, for example. And these cases are still to be considered by the court. The court has not yet taken a decision. It will take like at least 2 years for a court to take a decision. And even when the court takes a decision for immediate measures, like for example, there was a court decision that considered that population in Gaza was at risk, and Israel was asked to take all the measures to ensure that the population in Gaza is not confronted anymore to risk of genocide by the court. Then it's up to Israel to implement these decisions. And usually states argue that they are implementing the decisions of international courts, but if they are really doing so or not, it's open only to interpretation. So it's very, very difficult at international level to ensure enforcement of international law. It takes long time to make sure that the rights that are recognized by international agreements are really implemented on the ground, unfortunately. So let's continue with the refugee law, and I'm coming then soon to the end of this presentation. What we have in terms of legal instruments at the international level. We have the 1951 Convention relating to the status of refugees, and then it was changed with a protocol in 1967. Why this changed? Because the 1951 Convention was actually limited initially only for Europe and also for cases before 1951. So it was really a response to the situation of refugees in Europe after the Second World War. And then states recognized that it was relevant also in other contexts outside Europe, and also like with the time there are still conflicts and wars in the world. So in 1967, states decided to extend the application of this convention to make its definition global and also its application global. We have then some regional conventions like the 1969 European African Organization Convention concerning governing the specific aspects of refugee problems in Africa, and in Latin America we have 1984 Cartagena Declaration on refugees. The 1951 Convention and its protocol are the global documents, and they recognize a number of important rights for the refugees. The right to non-refoulement, that means the right not to be expelled except under certain strictly defined conditions. The right not to be punished for irregular entry into territory of a contracting states, the right to non-discrimination, the right to decent work, the right to housing, land and property, including intellectual property, according to the national legislation. So in the same ground as nationals, the right to education, the right to freedom of religion, the right to access to justice, the right to freedom of movement within the territory, the right to be issued civil identity and travel documents, the right to social protections, and so on. So there are also more rights recognized in the convention, but these are the main ones that I thought important to highlight for today. There are 149 states that are parties today to the convention and its protocol. And actually speaking, according to international law, these states should have translated the international obligations by the convention into national legislation, and they should ensure that the national legislation, which is in line with the international convention, is implemented on the ground. Unfortunately, we know that this is not always the case for many reasons that we discussed, and also we see that the states, they also try to justify many cases by saying that, no, but this is not exactly what the convention means, so we are still trying to comply with the convention by doing it differently, and it is our competency to ensure the way we do it. So what is a definition that we have of a refugee? So a refugee is considered a person who is owing to well-founded fear of being persecuted for reason of race, religion, nationality, membership of a particular social group or political opinion, and it's found outside the country of its nationality, and it's unable to have the protection of that country, or not having a nationality and being outside the country of a former habitual residence, is unable or owing to fear is unwilling to return to this country. So there are different elements here that are very important. The first is that the person should be persecuted, and then the definition gives a number of reasons for persecution. So it's race, religion, nationality, membership of a particular social group or political opinion. This person should be unable to have the protection of its own country. So being persecuted means also that the country that persecute cannot protect you. And because you don't have a protection of your own country, then you look for international protection. You are fast entitled to go to another country, and this other country should offer you this international protection that your own country does not give you. And there is also the case of a stateless person, who is the person that even though they don't have a nationality of a specific country, they have been persecuted by the country in which they were living before. So to be a refugee, you need to have a status determination process. This means that the state in which you find yourself, the host country, or in some cases UNHCR, will look at your specific individual situation and conclude whether your situation complies with the definition that is given here. So if you have been persecuted for these specific reasons that I mentioned here, and whether your country of nationality is not provided you with the protection you need. When there are many people that are forced to flee their country of origin at once, what happens often is that instead of doing like an individual status determination, you can do like a refugee status determination to the whole group on a prima facie basis. So if there are, for example, people that leave Sudan now, instead of doing like a individual case status determination for each of them, one state can decide that we know the situation in Sudan, we know that there is a war going on and that people feel persecuted because of a situation. So all the people that come from Sudan, we give them a prima facie, we accept them as a refugee. So we don't do an individual case determination. We also had one question in the chat box about the non-refoulement. And the non-refoulement, it's the basic, it's the core actually protection when it comes to refugee law, but it also applies to migrants in certain cases. And I will explain how it applies to migrants as well. So for refugees, it is recognized under international refugee law. It is recognized in the 1951 Convention, Article 33. It says that no state should refoule a refugee. So it means like should return it to his country of origin or to another country where his life or freedom is threatened on account of his race, religion, nationality, membership of a particular social group or political opinion. So here you have the different elements which needs to be taken into account. So you cannot be returned into a country where your freedom, your life and freedom will be threatened based on your race, religion, nationality, or membership to a particular social group or political opinion. What states do sometimes is they say like, oh, now the situation in this country has improved and a refugee can go back to this country because there is not anymore any risk to his life or freedom based on his race, religion, nationality, or membership to a particular social group or political opinion. We see it, for example, now in Syria, with the situation change after the fall of Assad regime. Many states, even in Europe, said like, okay, now refugees, Syrian refugees, maybe they can return to Syria because their life is not anymore threatened because they were against, they belonged to groups who were against Assad regime, even though the other situations have not changed in Syria. So under refugee law, asylum seekers and refugees are protected against refoulement, but there is an exception. They should not be considered a danger to the security of a host country or its community. So if you are an asylum seeker or a refugee in a country and the country considers that you are a danger to its security, then this country is allowed to return you back to the country of origin or another country based on international convention on the refugee. Now, as I mentioned, you have also protection under international human rights law. And this is a bit different because under international human rights law, you cannot go to any country where you will be on the fear or threat. You will be in danger of being subject to torture. And here there is no exception. So you cannot even be returned if you are considered to be a danger to the host country. So you see that sometimes the international human rights law offers a bit more of protection than international refugee law, but here it's also very much limited to torture. Very quickly, also a bit about the difference between the regional instruments and the Global Refugee Convention on 1951. Both the African Convention and the Cartagena Declaration, they have extended the definition of refugees as per 1951 Convention, because there was very much limited to persecution, while this convention look at really the context of crisis in the regions, and they look at external aggression, occupation, foreign domination, or events seriously disturbing public order. So it's much a broader definition in the convention, in the African Convention. And the Cartagena Declaration is also much broader, the definition of refugees, and it looks to people impacted by generalized violence, foreign aggression, internal conflicts, massive human rights violation, and other circumstances that seriously disturb public order. So these are a bit the international legal frameworks, and then very much to close, we also have two global compacts that were signed by states in 2018. One of them is the Global Compact on Refugees, and the other one is the Global Compacts for Safe, Orderly, and Regular Migration. These are not legally binding documents, so they are aspirations for states. This is where states would like to be, but they are not legally obliged to implement them into national legislation. However, some of this content of some of global compacts can be used to implement existing international law obligations, and they pursue a number of objectives. And for each of the objectives, a list of measures is provided in the text of the documents. And these are really to guide states to do better in protection of refugees and migrants at the country level. So these are really like for states that wants to do better at the international level, we have guidance how this can be done concretely in practice. And I think I will leave it here. So thank you very much, and I will look now again at the questions that are remaining in the chat box, and in the same time open for other questions. And I know that we are running out of time, so I don't know if you can continue to remain for another 10 minutes for questions and answers, and then I suggest we close. Would that be okay for you, Lou?
Absolutely, no problem.
Okay, perfect. So in the questions first in the chat box, I think we have one question by Okori Bunubura. Many people in refugee camp settings today continue to suffer from human rights abuses, which can deeply impact their safety. Yes, this is correct. And again, I mean, there are many organizations that are working to improve the situation and the human rights situation in the refugee camps. There are also governments that are trying to improve the situation. There are also governments that unfortunately are not doing enough to improve the situation for different reasons, lack of capacities, lack of political will, sometimes very often. So it's an ongoing fight, actually, I have to say. And I really think that we sometimes do not support enough the role of organizations that provide legal aid to refugees. Because they can bring cases to court and continue to push the government to improve the situation. I see Kakuma has raised his hand. And then I will look also at the question of Richard, but maybe first to Kakuma.
Thank you very much, madam. Are you getting me well? I'm by the name of Sam Abdul. I'm very happy today to meet this discussion of an international legal document. For me, I try just to ask a question about how does this international law on human rights and refugees reinforced on the country that have been hosted refugees. Like let us talk example like Kenya. Now Kenya is a country whereby having its own constitutions, having its own governor that which is governor the countries. But now when it comes to the Act of 2021 to the Refugee Act, you find that it lays with the Kenya constitutions now not international, because when it talks to an international, it's a global, which it cuts across, when it talks it cut across all over. But now me, I want to base on the Kenya, when it comes to the country that have been hosted refugee. Is that maybe a refugee that maybe like the service or the maybe the service being provided by the international organizations? Because we have the international organization, as you said before. Now, how does these international organizations give us a rights or the human rights to the refugees having a freedom of speech of saying something that what they need and what they don't need? Because in a Refugee Act of 2021, saying that they have to express their own problems and express their to listen to them. But you find out that now currently in the situation that we are seeing, is there something that we need to know about? So I don't know how that this international law it can reinforce the refugee to be voiced, be heard. As my other colleagues said about Sudan, said about Gaza, about other parts, how does this international help the other parts of the countries are having wars and to those human rights to be supported or to actually to be solved? Otherwise, thank you.
Thank you very much. As I mentioned, the implementation of international law, it's unfortunately a very long process to ensure that it's done properly. In the concrete case of Kenya, for example, already to have the status determination as a refugee, this is done by the Kenyan authorities, but they need to have a law on this. What are the criteria? When is a person considered a refugee? And these criteria in the national law are based on the international legislation. So they look at the international definition of the 1951 Convention and the protocol. They look at the African Convention because they are part to it. So the Kenyan law, the definition that it gives to the refugees is in line with this international definition. Then also the rights that the international laws recognize of the 1951 Convention, but also the African Convention, should also be recognized for refugees in national Kenyan law. And if this is not done, then the different UNHCR, for example, or the African Union could tell to Kenya, but look, you have committed to recognize the right to work for refugees. But according to the national legislation, the refugees do not have access to labor market. So what are you going to do about it? So it's really putting like international pressure, dialogue, and a bit of shaming and blaming with Kenya so that Kenya changes its legislation to make sure that all the rights of refugees recognized in international convention are recognized also in national law. But again, this is not the end of the story. Even when Kenya recognizes all the international rights, international legislation, then it has to take the next step and to make sure that these rights are really implemented on the ground. And this is even more difficult because many states will say, but look, we have also many nationals that do not have access to a job now. So it's not only a problem for refugees, and we have tried for refugees, we have given them access to the labor market, but there is not enough jobs in the country. So we are doing our best. It's not anymore our fault. But here again, it's also like what more can be done, how you can work with private sector, for example, to have specific jobs for refugees and migrants, how you can invest into the skills for education of refugees so that they are better suited to labor market needs and can have easy find a job in the future and so on. So it is quite complex. It takes lots of efforts by different actors. But the first step, I think it is really to ensure that international obligations are translated into national legislation and then work with the government to make sure that this national legislation is properly implemented. I don't know if I answered this question, and I will look at the chat box now. Refugee human rights are infringed in the camp, and UNHCR other actors are reluctant in governing them. What implications or effect would it bring to the international law and refugees? If there is a reluctance to implement refugee law, international refugee law, of course it has a bad impact on the life of refugees, because the international law is really done with the idea of like how can we ensure that these refugees have the same conditions of life as nationals without discrimination. So once the laws are not implemented, it will have an impact on the life. The refugees might not be able to send their children to school. They might not have access to labor market. They might not have enough access to food. Their health that might be at risk, and they might not have access to the health system, to healthcare when needed. So it can have a very, very negative impact. And then it is really also for the refugees to try to get organized, to come up for and to stand for their rights. If you seek to stand up for your rights as only one individual, you are in a weaker position than when you come together, get organized together, and there are different strategies to stand up for your rights. Sometimes you can be very, very soft in your approach. You can try to, especially when you are in friendly relations with the government or with an governance of a camp, and you see that they are trying to improve the situation, but they don't know how to do it. So there it's really to be constructive and to say like, okay, but why don't we try this? And we think that if you try this, we can also support doing this, and then together we can manage to improve the situation. But sometimes it's really lack of political will. And then it's like, how can you work with other actors that can put pressure, including political pressure, to change the existing political will? How can you work with the media so that they also put some public pressure on the authorities? So there are very different tactics to follow, and many NGOs do that. And there are also NGOs that are really into service provision, and they do not get engaged much into advocacy and putting pressure on the government, because then they are afraid that the government will not allow them to provide any more of the services for the refugees. Yes, and there is unfortunately many children that do not attend school to lack of resources or discrimination. Again, this is a violation of the right to education of every child that is recognized under the Convention on the Rights of the Child, and the right to education is also recognized in the 1951 Convention on the Refugees. Many national legislation recognize the right to education for every child, including refugee children. So it's really to say to the government, like, how can you support this refugee child to access education? Because this is what you have committed yourself to do, both in national law and international law. But when UN has to use its power for ending the wars. Yes, I totally agree. And I have to say that we said at the beginning, if you remember when I spoke about the subjects of international law, the main subjects are the states. So if we want to really to ensure a better implementation of international laws, states have to commit to do more about it. I think when we speak about ending wars, UN has been quite active, especially recently, outspoken about wars and context of human rights violation, context of international humanitarian law violation, asking for these situations to come to an end. I think states can and should do better and should do more to bring an end to the wars and to the violation of international laws in many contexts. And when we speak about states, we speak, of course, about the states that have more power at the international level. We speak about US, we speak about EU together, we speak also about the African Union together. If the states of African Union come together, have very clear political messages and stand firmly by these messages towards other states at the international level, I think we could have a better implementation of international law. So I think we can continue this situation for this discussion for quite some time because, of course, as I mentioned, the fact that there is a discrepancy between international standards and daily reality creates frustration in everyone. I completely understand this. But I think we need to close maybe now, so because yeah, I guess many of you have also other engagements. Lou, would it be okay to wrap it up and close?
Yes, absolutely. We are ending the end of our time. Yes.
Okay. So, colleagues, this is what I have to share. It was a pleasure to have this discussion with you today. I think I do understand that the legal framework, the international law, it remains a bit of a complex subject. It has a very good intention behind it, really to improve the life of humanity. It really considers everyone equal with the same rights, no matter where you are living, no matter your belonging to race, to nationality, to religion or other political groups. But of course, it remains not implemented everywhere. And I think it's important that all states, as the main actors of international law, main subjects, work together, continue to work together for a better implementation of international law, and really stand together against those states that do not implement protection of refugees and migrants as per international law. So I will close it with this, and I hope we'll have other opportunities to exchange and continue this discussion. Thank you.
Thank you very, very much, Mirela, and we look forward to further discussions on this topic. So that wraps this up, ladies and gentlemen. If I have recorded this entire workshop, and I will communicate this on the InZone website. So this entire presentation will be available on the InZone website in the coming days. Thank you again, everybody. Thank you again, Mirela. It was very, very interesting. I wish you all a very good day and all the best.
Thank you. Bye.